Turn to the fourth case on this morning's docket. That is case number 115776 in the matter of the paternity of SMJ, a minor, by and through her mother and next friend Whitney D. Jacobs, appellee, be David Roy Ogle.
May it please the court, David Brown appears on behalf of Whitney Jacobs, who is also present in the courtroom. We are ready to proceed.
May it please the court, Your Honor, the appellant David Ogle appears in person through counsel Mark Berry. We are also ready to proceed, Judge.
Please take your positions at council table and continue.
May it please the court, my name is David Brown. I do represent Whitney Jacobs, the petitioner at trial level, appellee at the Court of Appeals, and petitioner before this court. I am requesting 3 minutes of rebuttal time, if I may.
3 minutes is granted.
Thank you. And as a preliminary matter, Your Honors, I'd like to thank you for taking this case. The basic facts in this case, it is a parentage action, although the parentage issues are not irrelevant in this matter. The father has not seen his child in more than 2 years in any kind of legal context anyway. This case stems over a contempt action. A civil indirect contempt petition was filed. The respondent, Mr. Jacobs, was personally served with that. His attorney was served electronically through the court's electronic filing system and by email through our office. The appropriate affidavit for an accusation in indirect civil contempt was attached to the petition. The court issued an appropriate order to show cause. The order to show cause was included with the documents served on both Mr. Ogle and his counsel. Hearing date was set and included in that order to show cause, very clearly set. The hearing was held. Mr. Ogle failed to appear. His attorney failed to appear. They later acknowledged they both knew about the hearing but decided not to show. The hearing continued. The court refused to grant default judgment, and the court then found Mr. Ogle in contempt. We are here today because the Court of Appeals ruled that Mr. Ogle should have been present at that hearing, and it was a denial of his rights to hold the hearing in absentia. I'd ask the court a rhetorical question, if I may. What if Mr. Ogle and his attorney failed to appear today? What would this court do? My guess, and I have to guess, but my guess is that you would proceed. You would hear me out. You would issue a decision at some point based on the records before you, and you would move on. And if Mr. Ogle had some sort of a complaint about what you decided, he may or may not attempt to challenge that in some form or another. But the decision would be challenged, not the procedure to get there. And that's the problem with this case. First of all, it's important perhaps to have some sense of what the contempt was all about. Starting in 2012, Mr. Ogle started disseminating a variety of false allegations about my client and her involvement in Colombian drug cartels. He alleged she was a drug dealer, a money launderer, and that her arrest was imminent. In fact, in most of the court hearings since 2012, and you have in the record a detailed record of those, and there were many. In most of those hearings, Mr. Ogle would stand up and tell the court that my client would be arrested within the week. My client has never been arrested. No charges have ever been filed against my client. And all the allegations that Mr. Ogle has made are patently false. The trial court at some point ordered Mr. Ogle to stop making these allegations and spreading these kinds of lies and rumors until some sort of formal court action was taken against my client. He continued to spread all of his gossip, basically, and make all of his false allegations. My client was a school teacher. Mr. Ogle is self-employed at this time. And in 2015 and 16, he contacted the school district where my client worked and told the school district that within a week, there was going to be a story in the local newspaper about my client being a drug dealer, and did the school want that kind of association with a drug dealer and a teacher in their school, and shouldn't they do something about that? The school investigated, and my client obtained representation, and a mutual agreement was reached that my client would resign. This was like November, December, maybe January. My client would resign, the school district would pay her throughout the entire school year, and she would look for work elsewhere. As a result of those actions, clearly she was forced to resign her job. She lost income, she had attorney's fees, and a variety of things. And more importantly, Mr. Ogle was clearly in violation of the court's orders that he not talk about these miscellaneous allegations. And for the record, despite Mr. Ogle's claims in various pleadings, if you read the transcript of that particular contempt hearing, the school district never conducted its own investigation, never confirmed or proved false the allegations that Mr. Ogle had made. So, we prepared the affidavit in indirect contempt, and this is really important. The affidavit in indirect contempt was specifically for an indirect civil contempt. That's what that document said. The affidavit, the motion for the order to show cause, motion to cite him for indirect civil contempt. The affidavit said indirect civil contempt. The order to show cause said indirect civil contempt.
Counsel,
I'm sorry?
I understand that your opponent's made some issue about criminal contempt versus civil.
He
but
has.
The statute that the Court of Appeals decided this case on,
Yes.
The question of presence or absence, doesn't differentiate between civil and criminal, does it?
No, it doesn't.
Not on that
Yeah,
point.
that's 2012-04A. No, that statute does not. In fact, I think it's subparagraph D that specifically says it governs both kinds of proceedings. The important thing is, and the standard of review for this court, I believe, is, it's reviewing the statute. What does the statute require? Your review is de novo. So the appropriate thing to do is to look at that statute. What I'm attempting to show is that all the procedural requirements for an indirect civil contempt were met. And equally important...
Just to jump ahead.
Yeah.
It seems to me the statute's pretty clear that when the person doesn't show up, the district court has the option of issuing a bench warrant
Yes.
to get the person in front of them. That didn't happen here.
That's correct.
And why aren't we done? I mean, why isn't the district court required to follow the statutory procedure that's set
Well, Your
out?
Honor, I think the key is in the words you use to ask the question. The court has the option. The statute specifically says when the person does not appear, the court may issue a warrant for that person's arrest. We're talking about subsection
So you're
C.
saying it's implicit that if the court doesn't want to do that, it can do anything else it wants
I believe
to do, and
that's-
you're just stuck.
No, well, Judge, I believe that statute gives the court the option and the discretion to determine whether it's necessary to issue a warrant. Paragraph B of the statute says that the notice should set the time and date of the hearing, and the court shall conduct the hearing at that time. Paragraph C says the court may ask for the non-showing person to be brought before the court by warrant.
Well, aren't there, the point isn't presence what is the point? You need to be present, and there's different ways to effectuate presence. One is probably the most extreme, is the issuance of a warrant, but there's other mechanisms that the court has to try to ensure presence at the next hearing, isn't there?
Judge,
I mean, I just think there's options that the court can use, and one of them is a warrant.
well, I agree, Judge, but the statute doesn't say that the person must be there. The order, and think about what this is. This is an order to show cause. The court has already reviewed an affidavit and made a preliminary determination that there is a basis to believe the court's orders have been...
And how can cause be shown if the person isn't there to show anything?
Well,
I mean, it is a show cause. It isn't appear and I'm going to decide based on what's been filed. It's you appear and show cause to the court
exactly.
why I should not.
Absolutely.
And so the question is, how can you have a show cause hearing when the person required to show cause does not appear?
There is an afterthought to that show cause. You appear and show cause, or I'm going to find you in contempt. That is really the afterthought with that. But more importantly, and I cite in my brief multiple instances and multiple cases going back to 1879, where this court, the United States Supreme Court, and other district courts have specifically held that parties in civil actions can waive their due process rights. Now, first of all, let's talk about the due process rights. Right to counsel. Mr. Ogle had counsel. Counsel had notice of the hearing. Counsel failed to appear. Counsel failed to advise the court that he wouldn't appear. Counsel discussed the hearing with Mr. Ogle. Mr. Ogle failed to appear. They knew about it, but did nothing. They could have filed all sorts of things. I understand the counsel was going to go in for surgery. He could have asked for a continuance. He could have done all sorts of pleadings with the court. Nothing was filed. Not a response to the affidavit in contempt, not a notice that we can't be there, nothing. So that's the first problem. Second, they've got counsel. You know, what are the due process rights? The right to see, be heard, hear the evidence against you. Mr. Ogle had that right. He had notice. All he had to do was go to the hearing as he was ordered in the show cause order. He chose not to. If he'd been at the hearing, he could have presented his own evidence. His due process right to do so would have been protected. If he had chosen to attend the hearing, he could have cross-examined witnesses against him. And it's important to note, the court did not find by default. The court had made me put on evidence, and the evidence was quite extensive about the violation. But again, I want to talk about the case law that says that a party in a civil action can waive their rights, their due process rights. And let me see.
Counsel, before you
Yeah.
declare, you've talked about with my colleagues the sentence in the statute, subsection C, that deals with the optional nature
Yes.
of issuance of bench warrant. But I really think that the sentence that doomed you in the Court of Appeals is the next one. And that sentence reads, when such person is brought before the court,
Yes.
the court shall proceed as provided in subsection B.
I respectfully disagree with you because what it's saying is when the court feels the need to issue the warrant and the person is brought before them, the court shall hold the hearing. There are multiple things there. It's just saying when you get that guy there, you got to hold the hearing. And arguably, what it means is you can't issue a warrant, let them sit in the jail for a while, and then sometime hold a hearing. It doesn't, I don't
It's
think,
just a temporal provision, not a condition precedent, is what you're saying.
yeah.
And the
more or
Court of
less.
Appeals treated it as a condition precedent.
Right. You know, if you take the Court of Appeals ruling, and perhaps some of you feel this is appropriate, but the Court of Appeals is rewriting this statute. It's rewriting it to say that the person accused of contempt must appear at the hearing. The Court of Appeals is saying this statute guarantees the person accused the right to be at that hearing. That doesn't explain the use of may in paragraph C.
Well,
If-
I disagree. And here's what I'm wrestling with something else, and we can get to that in a second. But the may part, the option, would give the district court the ability to not issue a bench warrant if they thought that the indirect contempt request had no merit. So you show up, they don't. The judge looks at it and says, "Nah, this doesn't work," and and so there's no problem there. But if you're going to make the person show cause as to why they aren't in contempt, then they got to be there. And so I think the statute makes sense that way. Here's what I'm wrestling with. is if we give the judge, and it works your way, if we give the judge the ability to dismiss a non-meritorious contempt request, then why can't the judge do other things like what you're suggesting?
Well, first, I always presume that the courts are acting appropriately, and that's where this court should go as well, I think. But part of the difficulty here is that although the statute governs procedures for both criminal and civil indirect contempts, there is a great body of law distinguishing between what's necessary for a criminal contempt and what's necessary for an indirect civil contempt. And my argument here is this is an indirect civil contempt. You know, this is not a point that's directly on point, but it troubles me every time I think about this case, and I think, you know, a homeowner can lose their home if they fail to show up at the forfeiture hearing on their mortgage when they failed to pay their mortgage. No appearance necessary, no counsel right, but they can lose their home. No appearance required. Default judgment, you lose your house. Here, we've got a case where he's fined $7,000, and if he doesn't pay the $7,000, the judge says you go to jail, and should probably address some of that. But, and the court's saying, oh, he's got to be there to protect his right to $7,000. There's just a disconnect in my brain for that, and I know it's not directly on point, but it just troubles me immensely. The point I want to make is the counsel for the other side is jumping to the penalty. He's saying that the penalty is inappropriate, therefore it was a criminal proceeding. I believe, and I think this court should find, it was a civil proceeding all the way along the line. That Mr. Ogle voluntarily gave up his right to be at that civil hearing. And I cite in my brief, and please, I want to rely on all points not addressed at this hearing, on the points I've made in both the petition for review and the supplemental brief, because they do a far better job of addressing some of these points than I'm going to have time to do. But that criminal analysis is not appropriate because this case did not start out as an indirect criminal. If the judge made an error in the sentencing, in the order, remanded to fix the order. I believe the order is correct, but I'll address that in my 3 minutes. Thank you very much.
Thank you, counsel.
May it please the court, your honors. Mark Berry on behalf of the appellant David Ogle, who also appears in person.
Counsel,
Judge.
I have a question. If a lawyer gets notice to appear at a hearing and some event in the lawyer's life is going to prevent that appearance, doesn't the lawyer have an obligation to notify the court?
Judge, at that point in time, my client had not been served. We had talked about it on the phone. I said I had surgery scheduled for repairing of a hernia that had broken loose again, so I was going in on a short notice basis. Mm-hmm. I said, if you get served, it should be continued, but if you don't get served, don't worry about it. I didn't know he had gotten served and was in the hospital.
Okay.
So I think that counsel, and I do take umbrage at that he started out with the fact that he said that I ignored a hearing and just decided not to show up. I practiced law for 29 years in the state, and I've never chosen not to be disrespectful to a court and not just show. And so as soon as I got out and was recovering at home and found out that an order was going to be issued, then I went ahead and filed a motion to set aside that order. And we did have a hearing, which was taken under advisement by the district court again. And then when I filed a motion to get parenting time for my client, the judge immediately the next day went ahead, took it out from under advisement and issued an order that she was going to help uphold the contempt proceeding. So I believe that at this point in time, the issue is what we are here for in front of the Supreme Court as far as due process is concerned, and why we still have this building. And I was here 29 years ago as a law student, in my last year of law school, and it looks the same as it does 29 years ago. Now, and I'm not making fun of that. What I'm saying is that because we have rules that when people walk through those doors, They have to wear certain things. They can't come in with soiled clothes. They have to take off their hats when they enter the room. We have to respect the furniture. We have rules to follow. Now, I haven't been here, but I'm sure on occasion those rules may have been broken and quickly rectified either by the court or by the bailiffs or by the clerk to make sure that they don't happen again. So if one of the rules is not followed, we don't throw out all the other rules. Counsel mentions the fact that if there is a default proceeding in a house and we're equating property now to a child and my client having rights to that child, which I think are total opposite ends of the spectrum here, but he's equating a default proceeding to an order to show cause. Were we noticed up for a take of default? No. We've already entered in the case. Unfortunately, I'm the second or third attorney in this case, but this case has been dragging on, and Mr. Brown has been the lead attorney for Mother since 2012, and we're still litigating issues in this case. And unfortunately, we've got a young child.
Isn't the only issue here, though, whether or not the statute required your client's presence at the hearing?
Exactly.
There's no other issue.
No
Am I
other
right?
issue.
So if the statute does not require your client's presence, you lose at least on the issue of whether or not the hearing could proceed. I understand you have a claim on what remedies the court might be able to pronounce.
Correct.
Which is
And
a separate
as Justice
issue.
Biles said in one of the first cases, I think it was, we did not cross petition on whether or not it was the criminal versus civil. So I believe that issue I cannot raise at this point. I just am in agreement with the court that it was, needs to be reversed based upon the fact that the hearing needed to be held.
How do we get to your preferred statutory interpretation? Is it, we typically have two paths. Is it the plain language, or is it that there's an ambiguity that needs to be construed?
It's the plain language. It says,
Well,
if the contemptor does not appear, then the court has the ability to go ahead and issue a warrant and to bring him to the courthouse and be held until he can be brought in front of the court.
Do you disagree with the Court of Appeals discussion about how there are two different ways to read this, and that the statute doesn't prohibit holding the hearing without the person's presence?
I disagree with him on that issue, yes. I don't believe it can be interpreted any other way than what the plain language is, the way it's written, and the way it's intended is that you have to bring the contemptor in front of the court to be found in contempt. It's an order to show cause, like you said, and one of the other justices has indicated. How can he show cause if he's not there? In a typical show cause hearing, who presents the evidence? The contemptor. Because there's been an affidavit that's been filed by the person alleging the contempt that says, hey, judge, they have done X, Y, and Z. Bring them in front of the court and let's see if they have the intent to do X, Y, and Z. Because part of contempt, as the court is well aware, you have to intend. You have to have the intent. And how can intent be proven if the contemptor is not there? It can't.
Well, that's not exactly true.
Well,
Because we accept circumstantial evidence of all kinds of things. So there was evidence put on in this hearing, just not from your client.
and Judge, how many other hearings do we have? That's what I think is so outlandish in this, is that a hearing actually was had without counsel and his client there, with evidence presented. How easy is that hearing? Nobody's cross-examined. Everything's just taken as gospel.
That does happen especially in other civil proceedings, though.
What other civil proceedings, Judge?
Well, anytime that the presence of the other party is not required. It may happen.
Default judgments.
And that's what I'm saying. But
get
you
it-
had to give notice for a default.
Well, he got served.
Yes.
Well,
I
I
didn't think
understand that,
was a
but it
debate.
wasn't set for default.
I mean, he was told to show up. I mean, I guess I've had more than one civil hearing back in the day when the other side didn't show up and we were off to the races and got court orders and did the things we needed to do because they had noticed that they were supposed to show up. I don't think it's that unusual here.
I think it's fairly unusual. And if this would have happened in Johnson County, they would have called me and said, what's going on here?
Or,
The judge had other options.
or to disregard a subpoena. Has that ever happened in your 29 years of experience?
Disregard a subpoena.
Yes.
It happens quite frequently in Johnson County, where people disregard subpoenas as witnesses, yes.
And what happens to those folks?
The case gets dismissed. Very rarely will the court issue a warrant to go pick them up. I have seen it occasionally in 29 years if it's a higher profile case. And they'll say, well, fine, we're going to go ahead and issue a warrant and go pick that person up to testify.
What if we alter the facts of this case and your client notified the court that I've been served, but I'm not going to be there, and he doesn't show up?
Then I think that makes the second part of that statute of 2012-04 kick in that says, if the contemptor secrets himself from the court and a hearing is had for that purpose, which I believe at that point the court could have said, well, we have the second option of that statute that says, hey, if he secreted himself from the court, then we can go ahead.
Well, I read that first sentence to be, in that event, the court again may issue a bench warrant.
And I agree. And can go pick him up again. I think it had several options as opposed to what they did.
Just so I'm clear, to go back to, I think it's Justice Stiegel's question, I want to penetrate that a little deeper. Would you say the plain language of the statute supports your position?
Correct.
And I think we all agree it does not specifically say you cannot proceed with such a proceeding unless the person is there. But you are interpreting the statute because, by negative implication, I suppose, when it says the court may issue a bench warrant commanding that person to be brought. You're saying that is all that can be done, basically.
That's what I'm saying. That's all that can be done. If the contemptor does not show up and was ordered to do so, personally served, then the option for the court is issue a bench warrant or reset the hearing.
And let's assume with that, we don't agree that it's plain language, that there are two interpretations or more, and that it's ambiguous. What can you point to resolve the ambiguity? Just context of the other language, or is there something else?
Well, I think the second part of the statute, and one of the other justices brought that up, was that at the end of the statute of 2012-04 AC, it says that if commanding the person be brought before the court to answer for the contempt, I think that ties it into the first part of the statute, indicating that he has to be there or she has to be there. The contemptor has to be in front of the court. And I think that second part of the statute go ahead and ties it into the first part to make sure that there is no other way to interpret it. And I don't know if that answers your question, Justice Sherman.
Yeah, so
Well,
that's all you have. I mean, I don't mean to say that may not be enough, but I just want, if there's
understand.
anything else that
I
I'm not.
understand.
To follow up on that question, again, I read the Court of Appeals opinion as finding that the statute's ambiguous, even though I don't necessarily see that they explicitly say that. But they do talk about two reasonable or possible readings of the statute. And the Court of Appeals appears to me to resolve the ambiguity by looking to, and I'm quoting, basic concepts of fairness and due process. Is that an appropriate, I guess my question is should courts do that when resolving ambiguities?
you had the advantage of sitting up there and being one of those courts that we're talking about, and I don't have that advantage. I do believe, though, that yes, courts, that's why we're here. Courts have the ability to do that, to resolve ambiguities.
We should just make the statute good, as opposed to trying to divine what the legislature intended.
And I wouldn't go too far as
Well, typically we say that the purpose of our inquiry into an ambiguity is to achieve the legislative intent behind the statute.
and I think that, but I think you have that due process, in this instance anyway, when you have a due process right, that you also are here to make sure that not only is what the legislature trying to do can be achieved within their intent, but also to follow the Constitution in due process. I think that also can be intertwined with what you're trying to accomplish in that reading.
In other words, we have an obligation to construe a statute in a constitutional manner.
Yes.
Does that conclude your presentation?
No, I'd like to get to, I have 1:33
Certainly.
left, and I just want to get to the last part of that.
You're not obligated to take all your time, but please proceed.
I did read that in the rules, just very briefly. I don't believe that the penalty that was imposed upon my client, that the court even had personal jurisdiction to award third-party attorney's fees for the defense of mother's actions through the school district, where she was allowed to resign and chose to resign from that school district, and then want to award attorney fees to and have my client pay those attorney's fees.
Why not? I mean, wasn't this, it was conduct that was in defiance of what the court had ordered that resulted in these costs and expenses. It was very clear throughout, at least from what I can glean from what we have here, is that you're not to engage in this behavior and continue to engage in the behavior that caused great harm to Mr. Brown's client. So why not?
Well, because I believe that you've got two parents in a paternity action. They were never married. And so you've got the ultimate thing in this, which has really been lost, is the best interest of this child. And I don't see how you can go ahead then, Judge, and say, hey, you've caused damage to mom personally in her employment life.
Because you engage in the behavior I told you not to engage in that's affecting the child.
How's that affecting the child, Judge?
There was repeated
Well,
testimony.
I'm asking the questions, but
I
it's
understand,
obvious.
but I don't think it's affecting
it
the
is so
child.
plain and obvious to me that it's impacting the child. I don't need to answer your question.
And didn't the judge make repeated findings that this conduct was affecting the best interest of the child?
It's
And
all over
in
the
a-
place.
And I wasn't there, but yes, I
Previous
understand that that's
hearing.
what she repeated, that it was causing.
I have one more question that arises out
Yes.
of what you just said. You don't really mean personal jurisdiction. There's obviously personal jurisdiction over your client throughout this proceeding. He's appeared repeatedly. Counsel's appeared on his behalf. He's submitted to the jurisdiction of the court. You don't have to be personally present in every single hearing in order for personal jurisdiction to attach. That's an entirely different concept, right?
Not on a third-party action.
It's not a third-party action.
Sure
She
it
had
was.
damages. She was damaged by the behavior of your client. That's her allegation.
She was asking for,
Attorney's fees she
Attorney's
had to pay
fees.
in order to defend herself on the basis of your client's spurious allegations.
but to defend herself in a different proceeding. Correct?
In her dispute with her employer. But the proceeding is, I mean, there's clearly personal jurisdiction over your client in this case, right? In this paternity action, there's personal
I
jurisdiction
don't
of
think
10
in that
years ago.
third-party action, no, I don't think there is, Judge.
Okay, there's no action there at all.
Thank you.
All right, thank you, counsel.
Thank you for letting me go again. First, I want to make it very clear. The rights to see this child, visit with this child, be a parent to this child were not at issue in this case. Secondly, it was an order to show cause that was violated here. It wasn't a notice of a hearing or a phone call, please come to court today. It was an order.
So when the court, in the order that I just looked at, journal entry of the contempt hearing, when the court says, I'm now terminating all contact with the child, that was not part of the contempt?
That was part of the motion. I'm not sure which order you're reading, Judge, but in the contempt hearing, she did, let me back up. I believe that in the contempt hearing, she did say that his parenting time should be stopped until he resolved the issues that were pending, but none of those issues are before the court. And I'm frankly not necessarily prepared to address them. What I'm trying to say is that at the time, he had parenting orders that allowed him 2 supervised visits per week, and I believe it was multiple supervised phone calls. And the court cut those off because of his violations and his continuous actions that the court found harmed the child. And that was a relation to his actions that harmed the child. But it's not relevant necessarily to the question of, was the hearing conducted properly and was his presence necessary? And that gets to what I was saying before, Your Honor. If the court finds the penalties imposed were somehow improper, I believe they were okay. But if the court finds otherwise, I believe the proper remedy is to send this back for the court to fix the penalties imposed, not to find that the whole process was invalid. And I'd also ask the court, finally, what due process rights were violated for Mr. Ogle in this case? He had counsel. He had notice of the hearing. He had the opportunity, had he opted to exercise it, to be there, to interview witnesses, to present testimony, to do all the things that due process rights are designed to guarantee.
Isn't elemental to process just notice and opportunity to be heard?
That's definitely...
Even in a criminal setting?
Even in a criminal setting, you're right.
That's the element.
And I don't have time, I've got 8 seconds, but if you review the 2 briefs in this court and the brief in the Court of Appeals, you will see I've cited numerous cases that say that you can easily violate those rights. United States versus Gagnon from 1985. A defendant may waive his right to be present at trial by failing to assert that right.
You said easily violate, you meant easily waive.
I'm sorry?
You meant easily waive, not easily violate. You said easily violate.
Thank you. I
Okay.
appreciate it. Thank you.
But the legislature could add due process rights if it chose to, and that appears to be perhaps what opposing counsel is saying.
I think opposing counsel is trying to rewrite the statute, and I think the Court of Appeals attempted to rewrite the statute. I don't think that's appropriate under the circumstances. We have to do what it appears the legislature intended, and my point is, if the legislature intended to say that the alleged contender must be at the hearing, paragraph C would say the court must issue a warrant.
But Counselor, I understand the question to be that if we disagree and construe the statute as requiring presence, then that trumps your due process argument. That they can require presence
Your
even
Honor,
if due
you're
process doesn't dictate it.
You are absolutely right, Your Honor. If you come to that ruling, but in order to get to that ruling, my guess is the foundation for that ruling must be that it's going to protect some rights. And my question to you is, or my argument is, Mr. Ogle's rights were protected. He just said, I don't want to exercise them.
Thank you, counsel.
Thank
We
you.
understand your position. We thank both of you for your arguments this morning and this afternoon. The court will take this matter under advisement.